please.
All right, March 31st for the final status. All right,
Thank you, Your Honor.
2017 CR 18142, State versus Raleigh S. Conquest.
Judge, I believe he's still at large.
All right, we've reached the at-large docket, so we'll run through them all just to be on the record. 2025 CR 19762, State versus Michael W. Cook, at large. 2022 CR 19276, State versus Dylan James Decker, at large. 2021 CR 19111, State versus Joel Dickerson, at large. 2015 CR 17594, DeCarlos Fentress, at large. Any of these that we know anything about, interrupt me. Let me know. 2022 CR 19285, State versus Jessica Gomez, at large. 2024 CR 19549, Jorge Gonzalez Barragan, at large. 2021 CR 19114, State versus Damon Greenlee, at large. 2020 CR 19041, State versus Roy Kenneth Harris, at large. I'm sorry. He is? Is Roy Kenneth Harris? Is he in custody? Oh, okay. April. All right, we'll put him up to April 14th. Thank you. 2021 CR 19217, State versus Mary Johnson, at large. 2024 CR 19593, State versus Austin M. Lindsay, at large. (2025) CR 19719, State versus Don McLean. Is that the guy who did the song? Don McLean. Don McLean, American Pie. Well, I thought he was dead. At large. 2021 CR 19069, State versus Johnny W. McDonald, at large. 2024 CR 19594, State versus Christopher Dale Meese, at large. 2023 CR 19385, State versus Tatum Bradford Moss, at large. 2022 CR 19314, State versus Robert A. Perry, at large. 2022 CR 19268, Brian Rubenstoff, at large. 2013 CR 16885, John Shippers, at large. 2023 CR 19460, State versus Nicholas Antonio Shelton, at large. 2022 CR 19292, Raymond Daniel Skipworth, at large. 2019 CR 18919, Trevante D. Smelly, at large. 2023 CR 1938389, Deshaun Stone, at large. 2017 CR 18299, Aubrey N. Whitworth, at large. 2012 CR 16727, Destin B. Wigginton, at large. 2020 CR 19010, Mikey M. Womack, or Mickey M. E. Womack, at large. 2023 CR 19477, Edgar T. Harrison. That's the case that we have for 130 for sentencing. Charles Chambliss. Chambliss, you are filing an affidavit here that says you have no income whatsoever. Is that correct?
This courtroom hearing began with the judge calling a long list of criminal cases, but many of the defendants were still missing and listed as at large. One name after another was called, creating a tense atmosphere inside the courtroom. Then, the hearing took an unexpected turn when a defendant claimed he had absolutely no income. The judge began asking questions to determine whether the claim was true and if the defendant qualified for a court-appointed lawyer. What happened next caught everyone's attention.
Yes, sir.
How are you able to live if you have no income?
I'm living with my sister at the moment. I fell
Lift
about.
that microphone towards you. Pull that microphone. There you go.
I live with my sister at the moment. I fell about 14 months ago and severely broke my ankle. The bone came out the side. It was pretty nasty, but I haven't been able to work since.
So is all of the information in your affidavit true and correct?
Yes, sir.
All right, I find he is indigent and will appoint the public defender to represent Mr. Chambliss.
We will wait for formal reading, Judge.
We are not guilty as entered. General, what day?
7/14, you're on done.
July 14th. Your responsibility to stay in touch with your lawyer, okay?
Yes, sir.
Got a bunch of cases.
Marvin Jock.
Can have a conversation about the courtroom, please take it out in the hallway.
So you make $28 an hour according to your affidavit,
Yes, sir.
and for that $28 an hour, that equates to some $1,120 a week, which equates to some $4,000 or so dollars a month in income. What was your taxable income last year?
I'm not sure. I said I'm not sure. I haven't filed my taxes from last year.
Well, I find you're not indigent making that kind of money, so I will decline your request for an appointed attorney. What day are we setting this? General, if we're setting Mr. Jock off, for him to hire a lawyer. When do you want to have it set?
It's General Stevens, it should be in April.
All right, we'll set it for April 14th. This is an indictment charging you with DUI first offense. States that he's not eligible for appointed counsel, so
Might want to step in and play it for reading for him.
let me hand a copy of that indictment. But I'm gonna, yes, you can waive the formal reading of the indictment, but let's go ahead and give him,
Wait for him to read winner for the night.
all right, making $28 an hour. I do not find that you're indigent, therefore you're gonna have to marshal your assets to hire a lawyer.
Okay.
On April the 14th, you come back in and let the judge know whether or not you've hired one, okay?
Yes, sir. Thank you.
Thank you.
Should have him.
Rebecca Sipe. Mr. Vaughn,
Yes.
I've been handed a document. This is Shelley Knowles in docket number 1979686. Ms. Knowles has been indicated that you're going to enter a plea of guilty to aggravated assault, receive a sentence of 4 years, Tennessee Department of Corrections, suspended and supervised probation. If you violate your terms of probation, it would be a 100% service, meaning you have to serve every day of that 4 years. That's only if you violate your probation and go to prison. You must also have and complete a mental health evaluation and follow the recommendations from that evaluation and have no contact with Brian Hollingsworth. All right. Is that what everybody understands the agreement to be?
Yes, Your Honor.
All right. Ms. Knowles, raise your right hand. Let's place you under oath.
Yes.
State your full name for the record.
Shelley Jean Knowles.
Ms. Knowles, you've heard me go over what the agreement is, but have you seen or been shown a copy of the charges against you and gone over with Mr. Lockhart the range of punishment you're facing as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea to aggravated assault, then that would mean that the domestic assault is being dismissed. Is that correct? Count 2.
Yes, Your Honor.
All right.
The courtroom saw two very different outcomes in just a few minutes. One defendant explained that a serious injury had left him unable to work, and after reviewing the details, the judge approved a free public defender. But another defendant revealed he was earning $28 an hour. After hearing that, the judge denied his request and ordered him to hire his own lawyer.
But do you understand you have a right to plead not guilty to all charges and to have a speedy and public trial by jury?
Yes, sir.
You understand you would have the right to have a lawyer and have one appointed if you could not afford for your own?
Yes, sir.
You understand that if you went to trial, you would have the right to plead not guilty and that you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes.
You understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine all witnesses the state called to testify against you. You could bring in your own witnesses by using a subpoena.
Yes, sir.
You understand that you would be presumed to be innocent. You and your lawyer, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea of guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out with the state. You understand that?
Yes, sir.
You understand that's going to result in a conviction, and that conviction will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes.
You understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a trial and to an appeal by entering this plea of guilty?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes.
Anybody forcing you to do this
No,
against
sir.
your will? Do you understand if you plead guilty, the state or the court may ask you questions about the offense, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we find out you were lying under oath.
Yes.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty?
Yes, sir.
And are you guilty of this aggravated assault? What did you do?
Yes, sir.
What'd you do?
What did I do?
Yes, ma'am. What did you do to commit an aggravated assault?
What did I do?
Yeah.
I put a knife to his private parts.
To-
Yes, because
put a knife
I
to
did
this-
not.
this was someone you were
didn't want to no, I had not. I didn't want to consent to sex with him.
Okay, so you put a knife to this individual's private parts.
Yeah, I
Wow.
told him to zip it.
Anything further from the state? Are you satisfied with your attorney services?
Yes, sir.
You believe Mr. Lockhart's done a good job of representing
Yes,
your
sir.
confidantly? Mr. Lockhart, do you know of any reason she should not enter this plea?
I do not, Your Honor.
And Shelley Knowles in docket number 19786 upon your plea of guilty to aggravated assault, count 2 of domestic assault is dismissed as a part of the agreement. Court finds you guilty, sentences you to 4 years Tennessee Department of Corrections that will be suspended to supervised probation. And you, as stated, you if you violate your probation and are required to serve your time, it will be at 100% release eligibility. You must enroll in and complete a mental health evaluation and follow the treatment recommendations and have no contact with Brian Hollingsworth. She needs to see the probation.
Thank you.
Thank you.
Judge, I represent Ms. Clark. That is going to be for plea.
All right.
So she's pleading to count 3 and count 4. Counts 1 and 2 are going to be dismissed in settlement. Count 3, the especially aggravated sexual exploitation of a minor. It's a B felony. That'll be 10 years to serve in the TDOC, credit for time served. And count 4, solicitation of a minor, C felony. 6 years to serve in the TDOC. Concurrent with count 3, she'll have pretrial jail credits from 12/13/24 to 3/10/26.
All right. Raise your right hand and let's place you under oath.
Yes.
State your full name for the record.
Melissa Jean Clark.
Ms. Clark, you've heard what your lawyer's gone over, but have you seen or been shown a copy of the charges so that you and he have discussed the range of punishment you're facing as well as any possible defenses you might have to the charges?
Yes.
Well, it's indicated that you want to enter a plea of no contest. What that simply means is that you're not going to admit you did anything wrong. But when the state tells me what their evidence would be at trial, you're not going to contest that. And as a result of that, I will use that evidence to find you guilty according to this agreement. Do you understand that?
Yes.
You understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury.
Yes.
You understand if you went to trial, you would have the right to have a lawyer and have one appointed, as I've done with a public defender.
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Vaughn could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand that you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by entering this plea, you're waiving your right to that trial until the appeal. All I'm going to do is approve what your lawyers worked out.
Yes.
You understand that that's going to result in convictions that will be on your record in the future to make sure that, or make more serious the crime, the punishment you'll receive if you're ever get convicted of a crime.
Yes.
You understand that this is going to require you to serve a sentence in prison, and that is a 100% service, meaning that you will be required to serve 100% of this.
Well, it is 100%. She asked me if it was 85. I believe you get up to 15% of the pretrial
Right,
credits.
and she does get pretrial jail sentence. All right. And I believe it's more than right at 18 months or more that she gets credit for. Now you understand everything I've explained to you?
Yes.
Do you wish to waive your right to a trial by entering this plea of guilty?
Yes.
I'm sorry, plea of no contest. Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges?
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if this case went to trial. You may want to put your microphone over there toward you or come to the podium.
You ready, Your Honor?
You're ready.
Yes, Your Honor. In docket 19695 on September 9th of 2024, a minor victim who would be the biological daughter of the defendant came in for a forensic interview. She stated that she was laying in the bed with her mother, who was communicating with someone that they only knew as Boatman, and he had offered to give them money to film a video of the defendant and her biological daughter using a spatula to penetrate her vagina, meaning the victim penetrated the defendant's vagina with the spatula. This was recorded on Snapchat and sent to this Boatman individual, and she did believe that her mother did receive cash because they were behind on a phone bill. We do not have the actual video of the incident, but there is a recovered video wherein the minor victim and the defendant are discussing who's going to do what to who and why. And when the defendant sees that she's recording, it stops. Those would be the facts.
All right, Ms. Clark, I'm not asking that you agree with those facts, but you understand this, what the state's evidence would be if this case went to trial.
Yes.
You satisfied with your attorney's services?
Can I get that repeated? I didn't
Pardon?
hear you. I didn't hear you.
I'm sorry. Are you satisfied with your attorney's services?
Yes.
You feel like Mr. Bond has done a good job of representing you
Yes.
competently? Mr. Bond, do you know of any reason she should not enter this plea?
No.
Anything further from the state?
No, Your Honor.
Then Melissa Clark, in docket number 19695, upon your plea of guilty to, or plea of no contest, rather, to count 3, sexual exploitation of a minor, especially aggravated, I find you guilty, sentence you to 10 years in the Tennessee Department of Corrections. You'll be given credit for time served. Count 4, solicitation of a minor, you're sentenced to 6 years in Tennessee Department of Corrections. That will be concurrent with count 3 as well. She gets pre-sentence jail credits as set out on this document.
Thank you, Judge.
Just when the courtroom thought it had heard everything, a defendant entered a no contest plea to serious charges. That meant she wasn't admitting guilt, but she wasn't challenging the evidence either. As prosecutors described the disturbing allegations, the courtroom grew silent. Moments later, the judge accepted the plea and sentenced her to 10 years in prison, bringing a shocking case to an end. Comment below and subscribe the verdict files in USA for more shocking drama.